Okay, good evening, everyone. I am Rekha Panjwani, the moderator of today's webinar. We warmly welcome you to this event organized by the CCLEA and NPO Committee of ICI. It is my pleasure to moderate this DPDP Masterclass, Complete Guide to India's Data Protection Revolution for Chartered Accountant. Before we begin, let me briefly introduce the CCLEA and NPO Committee. This committee encouraged CA to help shape strategy and policy that drive economic, financial, and social value while applying a strong analytical and commercial skill. It focuses on analysis, knowledge sharing, policy input, and developing technical guidance and resources to support professional opportunities in commercial law, economic advisory, and NPO cooperative. Today, our eminent speaker will give us through India's data protection revolution and its implication for chartered accountant. We hope you find this session valuable. Now, it is my privilege to introduce our truly distinguished speaker for today's session, CA Harpreet Singh. Sir is an exceptional, accomplished professional, a CA with All India Rank 48, and also holding CMA, CS, CPA, FRM, ACCA, and an MBA from Power Business School, Spain. Truly a remarkable academic journey, showing such depth and a breadth of expertise. He has over 8 years of industry experience and is currently serving as a vice president at NetWest. He is also a reputed faculty and regular speaker for ICAI, ICSI, ICMAI, and many universities with the popular seminars on valuation, the digital personal data protection law, and the startup ecosystem. Today, he will guide us through complete guide to India's data protection revolution for chartered accountant. We are genuinely honored to have him with us. Sir, I now warmly invite you to please take over the session. The virtual floor is all of yours. Thank you.
Thank you so much, the committee and Rekha ma'am for inviting me and for the wonderful introduction. Good evening, everyone. So today we all have gathered to discuss the new law, and of course it's not new as such, but the implementation is yet to be announced, and the rules have been notified. The law is there, and we are going to discuss a lot of different things. Let me share my screen and start the deliberation. So yes, first of all, this session is I'm going to put it on full screen in a while. So of course, we are going to discuss about the DPDP masterclass, the topic that is what we are having today, the act that we have. First of all, we'll start with that, and then of course we are going to talk about the rules, because rules are the ones which are notified in January 2025, and the public comments were allowed till March 2025, and then how we are going to implement it for chartered accountants, what is the impact on chartered accountants, and basically what are the things, for example, if we can have the format of notice of consent, we can have the format of the agreement that we want to make with our client, and how we are going to actually maintain the data about the data. So yes, this is very interesting phenomena. Let us start the session and what we have in the house today. Of course, this is about the act, and there is a question on the applicability even till now, because it is a discussion that it is going to be implemented in the phased manner, and the phased manner should have started earlier, but it has not yet started. So, of course, we are going to talk about that. We are going to talk about the background first of all, because I am sure some people are new to this, some people have already gone through this. So, we are going to, and of course, the people who might have gone through this might have done it in the past, because it has been a sizable time since the law was made. And of course, we are going to start with the background. We are going to talk about the definitions. We are going to talk about applicability. Now, what is consent and legitimate use, data fiduciary, and how you are going to keep the data secure. There is an opportunity for chartered accountants also, how we are going to have that, and we are going to discuss a lot about other things. For example, yes, we are going to talk about various compliances that we are going to do. For example, various templates that we can have for our purposes as a chartered accountant. So for example, if I want to take the client consent, so how I am going to take the client consent, And of course, other things as well. Let me change it to one page. Yeah. So, okay, there we go. So yes, first of all, whether when we are going to take the client consent, so how we are going to take it, what is going to be the format, and if we are going to, for example, uh, uh, intimate that there has been any personal data breach, so what is going to be the format, so that is also a part of it. And then there are a lot of different formats that we are going to discuss, what it includes and why we have included all those things in those templates. So we are going to work from the beginning and we will go till the end. So of course a long journey that we have to do today, and it's 2 hours, so we will not go in a lot of hurry. We will try to understand, we will try to stop, and we will try to assimilate what it is trying to say, what is the impact. And as a chartered accountant, what should be my worry for myself, and my worry or my focus for my client, or my focus on the new client. So yes, a lot of different things that we are going to talk about. And of course, when we talk about the law, the DPDP Act, when we talk about the rules, DPDP rules, all these rules and act are very small. For example, it is only 21 pages of law, for example, DPDP Act, and the similar number of pages for the DPDP rules also, and there is an explanation to the rules also, which is there. So of course, we are going to discuss a lot of different things, and we are going to discuss it one by one. Let us start with the first things first. What is this act all about? First of all, the act is Digital Personal Data Protection Act. So basically, these four words are very important in this act. So, second thing which I want to share is there are three parties on which this law is going to be applicable. And the parties are data principal, data fiduciary, data processor. Fine, sir. We understand that. Then there are two ways in which this law is going to be implemented. First is consent, and second is legitimate use. And fourth thing is there is one penalty clause and there is one rule. So basically, we are going to understand the combination of 4, 3, 2, 1 in this entire session. And of course, we are going to go beyond that. Fine, sir. So first of all, what is the background or what are the key questions that I have in my mind? For example, I am having the camera in front of my house, in front of my office. That is also collecting a lot of data, that is collecting images, that is collecting video. So is this, and this video and this image is of the people, of the individuals. So you are talking about the personal data and it is also in digital form. Is the DPDP Act going to be applicable on me? So yes, of course, first of all, we are going to discuss the applicability. Then second, sir, I have a lot of PAN, Aadhaar, credit card details. Say for example, I have the income details, I have the IPS, the investment interest. So for example, what kind of investment my client want to do. So I have a lot of information about my client. Is the DPDP Act applicable on me? I have a lot of information about my employees, and leave myself, my client also has a lot of information about my employees. Is DPDP Act going to be applicable to him? Then I am having, sir, a lot of information which is in my files, which is not in the virtual form, since the law says digital. So I am in my files having a lot of PAN cards, Aadhaar cards, a lot of different informations that is there about the client and about maybe his family or some other things. Is this law going to be applicable on me? Then I am having, for example, use of AI nowadays, right? So AI is also using a lot of information. I was also planning to use AI in my organization. Now, is the DPDP Act applicable on me? And is it going to be a change which is going to happen? Say, for example, I want to use ChatGPT or Claude or any other. So there are a lot of questions that I'm having in my mind. And by the end of the session, we will try to answer those questions. And of course, apart from that, if you are having any other question, we will try to answer those as well. All right. So this sets the expectation for the session that we are having today. Now, these are the same questions that I was discussing with you. What is the background, sir? Background of this whole act? And of course, we know that this act was made on back of what? On back of the right to privacy, on back of right to privacy, which was declared as a fundamental right, as a fundamental right in this judgment, K.S. Puttaswamy judgment. And from here it started. So this started for the first time in India only, or it is anywhere in the world also? Yes, it is in the world also. It is everywhere in the world. Where it is there in Europe, it is there in USA, it is there in Brazil, South Africa, Bahrain, Philippines, Canada, UK. So a lot of places this law is already there, but it all started in 2016 when GDPR was, which is the gold standard and which is the first law for the data protection, and it was adopted in European Union. And when this law was adopted, I was also working for a bank which was there in Europe also. At that point of time, also there was a hue and cry that how this law is going to impact, and is there going to be a lot of cost? Are there going to be a lot of fines, penalties? Are there going to be a lot of work that we have to do in terms of okay collection of various data, what all data we have? Is it going to require a lot of efforts? So yes, this is where it started in 2017 in India. Supreme Court declared that yes, privacy is a fundamental right. Now, how you would secure this right? First of all, you will have to have some law if it is a fundamental right, right? And you know that whenever there is a constitution, that constitution is having further law acts which is going to be implemented to protect the constitution and to protect the fundamental rights. So for this also a law was to be made, and then committees were formed, JPCs were formed, and then later on in July, DPDP bill was approved by the cabinet, and then in 2023 DPDP Act was signed by the president also, sir. So from 2023 till now it is July 2025. So what happened in this time? Is there any progress which has happened in this time, or nothing after this? So yes, there's a progress which has happened in this time. So when the law was passed, thereafter in 2024 there was a focus that yes, the law should be implemented, and at that point of time the government was thinking to implement the law in different phases. So when I talk about phases, it is not going to be implemented at once, but it is going to be implemented, for example, to the bigger uh, parties, to the companies which are having turnover of, for example, more than 100 cr. So this is just an example, I don't know, right? And then to smaller companies, to smaller firms, right? This should have been the way, and this should be the way even now. But this was not implemented 2024 due to elections, a lot of other compliances that were there, and there was a lot of resentment, a lot of pushback from the industry. Why, sir? It would require a cost, and this cost, if it is a company, it is a big company having huge turnover, that cost is still lesser. Then what is the problem, sir? If the cost is, for example, 4 lakh, 5 lakh, 10 lakh, 15 lakh per annum, then what is the problem in implementing this law? And so first of all, this 15 lakh per annum, any small, medium organization, for them, it's a huge cost. Secondly, for the bigger organization also, it is a trouble. Why, sir? Because it is having small cost, maybe, but it is having huge efforts, and it is having huge penalties. All right. So this is the reason why this law was not implemented. Sir, is this the same case which happened with GDPR, for example? This law must also have been the same. Were there also a lot of obstacles when it was implemented? Yes, there was a lot of obstacle. Also, there was a lot of hue and cry also at that point of time also. And even in DPDP Act, we expect the same. All right. Then what happened in 2025? Draft rules. So for any law, for any act, there should be some rules which is going to be effective, which is going to be put in place so as to implement the act. So this law, these rules were notified in January 2025. The time was given till Feb 2025 that you give the comments. Of course, that's the way how it is done. So public comments, and the deadline was actually extended till March. And March is over, April, June, May, June is over. Now July is there. There has been no news about this rules. Okay, all right. But there are some news, some rumors that yes, there has been a lot of discussions with the industry, because a lot of things, even after the rules are notified, a lot of things are still not very clear. Right. We are going to talk about those. All right. So you know that what is the background? European Union, GDPR 2016. This is the background, and then there are a lot of countries where this law is already applicable. All right. In India, was there no law regarding this? Yes, there was a law which was Information Technology Act 2000, but it was having only limited extent for the data protection. We are going to talk about what that limited extent was and how it has expanded now. Now we know all of this, that 11 July, 11 August, this was assent was given, and then DPDP rules, public comments were to be given by 5 March 2005, and effective date is yet to be notified. We know already. All right, sir. When you're talking about that, yes, penalties are huge. Was there penalty? Huge penalties were there in GDPR also. Huge penalties are actually applied in GDPR also. Yes, that is very true. There are a lot of highest penalty GDPR fines are applied on different companies by different countries. Okay, these all are European countries. This is UK, right? So basically, you can see for 2 billion, 3 billion dollars, euros, this is the fine, this is the penalty which is implemented now. And there are companies also on which this huge fines are implemented, right? You can see all of these companies, and the reasons you would understand, you would see it, you would be shocked. Somewhere, some organization even did not know, airline company, right? Which one is the airline company? British Airways. So this company even did not know that someone is actually hacking their website, hacking their data, and whoever, whatever customer is coming to their website for booking the tickets, the data is going to somewhere else also. They did not know. They did not know about the hackers. They did not know about the data theft. But then also they were said to be penalized. And what was the penalty? 22.4 million euros, right? Some organizations, some company did not allow to use their website, their services without allowing the cookies. So, for example, Google was the company, and at that point of time, 90 million euro was fined. Then in some company, what happened was there was a health record of the employees, which were accessible by other employees also. So ideally, if I am having any disease, my colleague should not know. Of course, then it might create that embarrassment or something like that. I might not be comfortable, right? He can take advantage of that also, he or she, right? So lot of different things, and then the fines were implemented. And at some places, for example, on TikTok, the fines were implemented because it showed the content which was not appropriate for the children. It showed the content which actually glued the children to the screens. So a humongous fines were actually implemented, were applied, and were even taken from these companies. All right. So we know that worldwide the impact is very huge for all the companies. And in India also, the impact is going to be huge. That is why there is a lot of waiting time. There's a lot of discussion time. There's a lot of public comments, etc., etc. time before the implementation. All right. Then let us discuss about the applicability, when this law is going to be applicable to me. What are the circumstances which will say that yes, okay, now the law is applicable on me? Let us understand. So the law says that DPDP Act apply to processing of digital personal data. Number one, it should be digital. Number two, it should be personal. That means it is applicable to individual data, not company data. All right. And this data within the territory of India. So it is saying processing and within territory, one and two. So processing means use. I am using the data. Simple. Using the data for calling. You are getting a lot of calls from some company, and that company is saying that you take loan from us. You are selected for the credit card, for example. So it is using your data for calling, for pitching, for marketing, for something like that. Someone is saying that you are having a plots in Noida, right? And the usage is happening within the territory of India. So someone from India is calling you, right? Someone from India is calling you. You are also in India, that person is also in India. Then where the personal data is collected in digital form, in non-digital form, and digital subsequently. So now what kind of data is being used? The information, the data which was collected in digital form. So the number was saved in a spreadsheet, for example, right? On a computer, in my mobile phone. So all of this, it was a digital record, or it was collected on a printed form, but later on it was converted, it was uploaded in the spreadsheet, it was uploaded in my database. So both the things can happen. Either it is a digital data collected digitally, or it is a data which was collected manually, but it is now in a digital form. So I'm using that data where in India to do what? To do anything. Usage can be any kind of things, and data is personal in nature. All right. Then this act is going to be applicable. So sir, if I am in UK, if I am calling someone in India, then it is going to be applicable. Or if I am in India, sitting here in India and calling someone in UK, is it going to be applicable? So there are a lot of questions, right? Now let us talk about that. The act also apply to processing of digital personal data outside the territory. So it will not happen that you are not having your call center in India, you are having your call center in Nepal, and you are very smart, sir. You are saying, I will have my call center in Nepal, and from there I will call the people who are sitting in India just to avoid this law. No, it is not going to be helping you. Then if if the processing is outside the territory of India, but the processing is in connection with any activity which is relating to offering of good or services to data principal within the territory of India. So same thing which I mentioned. So how I am going to determine the applicability? First of all, the usage is in India for Indian people, or usage is outside India, but it is relating to Indian people, then this law is going to be applicable. Second condition is it is going should be in the digital form, whether from the very beginning or later, right? All right, sir, we understand the applicability now. Non-applicability, are there some areas where it is not going to be applicable? When you are using something, some data collected for personal or domestic purpose. So for example, if there is a camera outside your house, then this law is not going to be applicable, although you are collecting digital data and you are collecting personal data, because we are collecting the photograph and videograph, but that is purely for the personal or domestic purpose. You are not uploading it on YouTube, and you are not saying that yes, I am going to take out any revenue or something like that from this law. All right. Or second thing is, sir, if it is publicly available and it is made available by the data principal himself. All right, sir, it is publicly available, and that availability is because of the data principle. He himself uploaded on a website, on Instagram, or something like that. Then this law is not going to be applicable. All right, sir. Now, focus of that, we understand that the focus is digital personal data and how to protect it. This is the focus of the area. Now, what data is? Data means any information, fact, or concept, opinion, it can be instruction, it can be interpretation, it can be processing, either by human or by automated means any information, any fact is going to be a data, right? Data means this. Now, but what personal data means? Personal data means a data which is about an individual, right? It should be about an individual, not about company, not about LLP, not about partnership firm, and using which I can identify someone, or it is in relation to some identifiable data. So anything by which I can identify someone, I can identify someone through height, some video, some audio, some photograph, some numerical data, graphical data. Any kind of data is going to be part of this definition, because we want to actually give the protection to a wider group. So that's why, so personal data means anything and everything by which you can identify any person, right? So person means individual, right? All right, sir. We understand that data are of two types. One is that the data non-personal data, and another is personal data which belong to individuals. So non-personal data, company, LLP, partnership. So this is not going to be party to this law. Why? Because they are not going to be protected under this law. It is only about the individuals, it is only about the personal data. All right. Then personal data also are of two types. What two types? One is the regular personal data and another is sensitive personal data. So what is regular personal data? Regular personal data is your name, your phone number, your email ID. This is regular personal data. Now what is sensitive personal data? Any data using which you are going to take any benefit, or you are going to harm someone, or it is very very secret kind of data. So what that data is: your password, your bank account details, your credit debit card details, your health records, your sexual orientation, your biometric data. So these are the sensitive personal data which you are not comfortable at all sharing with someone, right? A stranger, or even to the ones who are close to you, who are your friends. You are not comfortable sharing with them possibly these things. And how you know that these are the only data? Because it is defined in SPDI, this law, Information Technology Act, SPDI rules, it is mentioned already. All right, sir. We know the applicability. We now know the non-applicability. Now what we have to do is we have to focus on the parties. All right. So what are the parties? There are three parties. First is data principal. This is the hero of this whole law, because this whole law is made for the data principal, the person for whom this whole law is made, who is the owner of the data, the real owner of the data. Data is about him or her, right? Then data fiduciary. Data fiduciary is the one who is taking benefit of the data, or who is using the data, in a way you can say. Is taking benefit out of data, who is getting data from the data principal, and who is the data processor. Now, data fiduciary has given some data to data processor to do some action. What is the example of data processor? Data processor is, for example, a parcel company, right? So you are getting phone number and you are getting email ID from the data principal, a person who has bought the phone, and you are Amazon. So this person is data principal, and then you are Amazon, you are data fiduciary, right? And who is data processor? That, for example, delivery is the data fiduciary. Now you have got the phone number, you have got the email ID, you are passing it on to delivery, that yes, take this data, take this phone number, and take this email ID, contact this or address, contact this person, and deliver this product to his or her location. So basically, you now understand what are the different parties which are here. All right. Now, let us understand it deeply. Data principle, to whom the data relates. If it is a child, then what will happen? Its parent or lawful guardian is going to be data principle, not the child himself. Why? Because there is going to be a consent. There is going to be an agreement between both of these. A child cannot enter into any contract. That's why he is not data principle. Second thing is where an individual is a person with disability, then the lawful guardian who is acting on his behalf. These are two exceptions regarding the data principle. Otherwise, to whom the data belongs, he is the data principal or data subject. Second, who is data processor and data fiduciary? Data processor, a person who use the data on behalf of data fiduciary. All right, sir. So data fiduciary, he is the agent of the data fiduciary or employee, kind of employee of the data fiduciary. Now, who is data fiduciary? He is the person who is having the maximum liabilities in this law. So basically, any person who alone or in conjunction with other person determine the purpose and means of processing. So basically, he is going to decide for which purpose the data is going to be used. All right, sir. And now the data fiduciary can process personal data only as per the act and for a lawful purpose. So two things should be there before using the data. What those two things are? First of all, consent, and second is the legitimate use. Consent and the legitimate use. All right, sir. Now, what do you mean by consent and legitimate use? We understand that there are four terms in this law: digital, personal, and data and protection. We understand that there are three parties in this law: data principal, data fiduciary, and data processor. We understand there are two ways in which you can use anyone's data or information. What those two ways are? It is consent and it is legitimate use. Right? And one is the penalty. We are going to discuss about it. If you don't do 432, you'll have to face the penalty. All right. Then what is the consent? Consent simply means I agree that you use my data for this and this purpose. And that's it. But consent has some conditions. What those conditions are? The conditions which were there in Indian Contract Act, more or less. Okay, all right. First of all, it should be free. Free means what? He is not under any pressure. Specific, he has given that consent that yes, go ahead for the purpose or for the use which is very specific. You cannot make an agreement, you cannot get a consent from a person who's and say, I'm going to use the data for anything and everything. No, it's not like that. You'll have to specify for what purpose. Not anything and everything cannot be part of your agreement. You have to specify, okay, for what purpose you are going to use. And it is going to be informed. Informed means that person understand that yes, he is going to use my data for this purpose and this is going to be the impact. He is going to share my number with 10 people and this person is going to call me in the morning, in the afternoon, in the evening, and in the night. So he should be very well informed. All right, sir. Now, and it should be unconditional. There should not be any condition attached. We understand that for Google, there were certain cases in which Google said, you cannot use my services if you don't allow all cookies, right? Sorry, sorry, there was a call. So unless you don't allow all the cookies, so it should be unconditional and it should be unambiguous. It should not be like you have written a lot of paragraphs and somewhere you have mentioned a small thing in one or two paragraph. No, it is not going to happen like that. You have to make a separate agreement. All right, let us see what kind of agreements are made and thereafter we will go through this again. All right, sir. I am stopping to share this presentation. Only this presentation I'm going to stop. All right. So now what are those things which I'm going to show you? I'm going to show you what are the consent notices like. So for example, this client consent notice is separately for different services. For example, you are going to prepare the tax return. Secondly, you are going to give him the financial advice. Right? Thirdly, you are going to give him any other advice. You are going to make accounts for him, or you are going to audit. So whatever different kind of services, you have to have the client consent for each and every purpose, that I am going to use this data for this purpose. Now you will mention that what you are, what what is your information, you are firm, this is your registration number, and this is my contact, and what are the contact details. We are going to talk about that also. Data protection, contact details. Then you are going to talk about, okay, I am going to collect this data, this personal data. I am going to take this individual information, your name I am going to take, your date of birth I am going to take, your gender, PAN, Aadhaar, contact details, residential, bank accounts. So anything and everything that you are taking. Okay, sir, I have taken individual information. Then you have taken financial information also. Then you have taken family information also. Then you have taken any other information. Now you have mentioned, okay, about yourself, about the personal data. Then you will also mention about what is the purpose, why you are going to use it. You are going to use this for preparation and filing, maintaining statutory record, communication with tax authorities, compliance with Income Tax Act requirements. So you have clearly mentioned, okay, what are the purposes of processing and what is the legal basis. I am saying that your explicit consent is required. Legal compliance is required under this act, where I need to keep the records for this period. And data sharing, basically data sharing can be with income tax department, which is required as per law, with banking institution, our authorized staff involved in your case, and external tax consultant, only with your separate consent. Even if you write external tax consultants, you have to actually get a separate consent for that. You cannot mix it. It cannot be ambiguous. It cannot be a paragraph, a simple line, and then you cannot be saved by the law. Okay, data retention. You mentioned that till what time I am going to retain the data. There are timelines in the act itself, but I am going to mention about the uh, separate timelines also in different acts. So tax related document 6 years as per Income Tax Act. All the communication record 3 years. 3 years is the timeline which is given in the act. We are going to discuss about that, know about that. And marketing preferences until you withdraw. We are going to send you something if it is relating to tax only, sir. Anything other than that, I cannot send. If my client is for the tax purposes, only I can do marketing relating to tax, not relating to the financial advisory. Right, sir. Okay, what are the rights? Under DPDP Act, you have right to access. So all the rights, we are going to see what it is all about: consent withdrawal, grievance redressal, and what is the statement. And these boxes are not ticked automatically. You'll have to go and tick one by one, and that's how you are going to sign, date, name. All right, sir. Let us come back. So you have seen the consent form, how the consent form is going to look like. Let me go back to the presentation. Okay. All right, sir. So now section 6 says that consent should be free, it should be specified, it should be informed, it should be specified, it should be informed, and it should be unconditional, unambiguous, and affirmative. It should be an affirmative action. If you are putting a huge paper in front of any person, he is definitely going to ask about it, talk about it. You cannot say it is a regular agreement that I am going to have, because you have to take the consent separately. separately, not via a clause in your engagement letter. No, this is not going to happen, right? And it shall signify an agreement to process personal data for the purpose, and it will be limited to that purpose only, right? So notice required to be given, and for the personal data, and purpose should be mentioned. And you also saw that the purpose was mentioned, and it was also mentioned that it can be withdrawn at any point of time. Sir, what if a person says that I want to withdraw the consent? What I am supposed to do, right? So yes, we are going to talk about that later on. Now this is just an example. But consent should be related, like I mentioned to you, that you are giving tax services, but you are saying that I'm going to use for financial advisory. Sorry for the handwriting. Financial advisory marketing. No, sir. You cannot do it, the things which are not related at all. You cannot get consent of all the data, first of all. For example, any food app which is seeking consent for accessing photo gallery. So what you would do? Only if you have to file a complaint that yes, I got this food bad or not as per the benchmark, then they will say, okay, upload the photograph. For that, you are going to give the access to the photo gallery. Fine, sir, fine. But a music app which is seeking the location data, what music app will do about your location? So you can say that wherever I will go, it is going to play the location specific songs also. Why? Because there is an option, a new option in my music app, that click on the locals. For example, there's an icon called locals. You click on that, you are going to listen to the local songs of that place where your phone is. So yes, if it is relevant, you can make it relevant. You can introduce a new product, and that person also says, I want to have this product. But if it is irrelevant, it is not going to help whether you have taken the consent also, but you can't do. One other thing that you cannot include in your consent letter is, so for example, if he has given you data, you do something not quite right with that data, you sell that data, for example, for money, and he is getting a lot of calls. Then what he can do is, he can go and he can make a complaint about you in the DP board, data protection board, right? Although we will actually read that before going to data protection board, the the complaint should be resolved at the company and its own data protection officer. But you can say there is no data protection officer, that's why I have come to you. So yes, that can also be possibility, but later on we will see that. So now this person can go to data protection board. You cannot include in your consent letter that yes, I'm not going to go to any data protection board, right? So basically, you have to keep in mind that you cannot have any contract which is against the law, right? I have understood it very, very well. All right, sir. Now you understand that consent needs to be taken. It should be free everything, right? Should be relevant, and there should not be any details or any clause which is infringing the existing law. Fine, fine, sir. Now you have seen the consent letter, draft consent letter also, which you are going to send. All right, sir. For example, all of these things, when I say that it should be explicit, when you go to the website, you are going to see that yes, this is a message which you have start getting. Earlier, there was no such message, or only OK was allowed, right? But now the message says that you can manage preferences, you can change the preferences, and then you can say confirm my choices. And you can see that here is the vendor which is providing the services. The name is One Trust. So basically, are you saying that this law, when applied, is going to give chance to new organization, right? Newer organization which are into this domain only? Yes, this is going to be true, because so for example, for this small change, they have got a new vendor. This is One Trust, right? So the compliance of DPDP Act is going to require certain expenses also, having certain new vendors also. What those expenses are going to be, who those vendors are going to be, we are going to talk about that. Okay, but you can see that it is affirmative. It was not like when I click on manage, all of this is automatically ticked. This was unticked, and I have to go manually and select, and then I will say confirm my choice, right? So you're understanding it's an affirmative action. So whatever words are written there, we are making it in reality. Do like that also, right? All right. And you have mentioned in detail that yes, your data is going to be taken up by Google, Facebook, Bing, and LinkedIn. And this is the place where you can go and you can change your choices also, right? Fine, sir. What about the consent prior to this act? So what you have done is you are using already the data. This is for the new data or new client from whom you are taking the consent. But what about the consent which is already taken prior to the act? You are having the data already. You are using the data already. What about those data? So, for example, where the consent has been given for processing of personal data before the commencement, or whether consent was not given at all, only data was there. What is going to be the thing? So, the data fiduciary will issue the notice within the reasonable time. What the reasonable time is, we are going to discuss. So it is going to issue the notice to data principal. So basically what I am going to do, sir, I am going to see what all data I am having. I am having data about the 10 clients. Am I going to issue notice to all these 10 clients? As and when the act becomes applicable, yes, I am going to send the notice to all these clients, not only to the new clients. That is why I am having that notice format handy. All right, sir. And what that notice include? Personal data. What is the personal data? What is the purpose? What is the right? And what is the manner in which the complaint can be made? Right. So all of these things we have already seen in the format. And data fiduciary can continue to process the data until consent is withdrawn. So it's not like that you are going to send the notice and that person has to mandatorily reply yes. It's not like that. If that person does not reply anything, then you can keep using the data till the lifetime also. So till the time that consent is not withdrawn. All right. So this has made the work a little easy. Otherwise, on the implementation of that, what you would be doing, you would be sending the notices until the time you are waiting for the notice, you are not able to work on his or her data. That was or could have been the problem, right? All right. Now, and it should be in clear, plain language, and very important, it should be in English or any other language specified in 8th schedule. So basically, it is not your choice, it is that person's choice. So basically, you will provide in English also, plus you are going to provide in 28 more languages also. For example, how you are going to provide that? Basically you are going to keep a vendor for the same. So there are different vendors which are going to be there, and these vendors, there is a specific applicability. There is a specific condition which allow certain vendors to be there only. Not everyone can be a vendor, not everyone can do the data assessment or something like that. Not everyone can be a consent manager. So we are going to understand what a consent manager is, right? What is the limit, sir? 2 CR is the capital limit for this act for becoming a vendor. We are going to understand. Okay, all right. Now, and the contact detail of data protection officer. So if there needs to be a data protection officer, you have to mention the contact details of the person also. All right, sir. Now, who can be a consent manager? Data principal can manage or review consent through a consent manager. That means what? Sir, I am Ram, I am having my data with you. So what I can do is I have given you consent that okay, please go ahead and use the data. Now I want to see what data you are using after 2 year, 3 year, 5 years. I want to see what all data you are using, and I want to say, for example, for 1 to 3 purposes you were using, two are fine with me, but one is not fine. So basically, I will change my consent, right? So first of all, I'm reviewing and then I'm changing. So this is done through consent manager. So there is a person, there is an entity which is going to keep all the records who has given consent of what. Okay, can it be manual also? Can I do it myself also? So this is one of the discussion point that the government is having. Otherwise, this is going to be a huge cost, right? What kind of cost it is going to be? So for example, there are various companies which is providing this data consent manager services, and this is the estimated cost which is per annum, right? So these are various website. If you go to any website, you'll be able to see, and these are what, these are majorly the IT companies. You go and see that Perfios consent manager, full stack consent capture, storage across touchpoints. So it is going to store what all information I am having, what all information I am allowed to use, and what all purposes for which this information can be used. All right, so then number one was the consent. So you are getting the consent, and number two is the legitimate use. Sir, I have got that data for the text filing only. I am using it for that purpose only. Then why I want to have, or I need to have a legitimate consent, sir? It is a legitimate use, right? So that person came to me, that person made an agreement with me, or that person is paying the fees to me for doing that work. So it is a work which I will be do because he is paying. Why I need a consent over and above the legitimate? Sir, the answer is no, you don't need a consent over and above the legitimate use. That means, sir, then in that case, I am not liable to get the consent in most of the circumstances, because in most of the circumstances, it is going to be the legitimate use. This is true, but that there's a lot of, I would say, non-transparency or non-clarity of the provisions. So the best is to have one agreement with each and every client that we are going to use your information for this purposes. Even though the act might not be applicable on the first day to all the CA firms, but eventually, gradually, it is going to be made applicable to all later on. So yes, this is going to come anyways, maybe 5 6 months down the line, maybe 2 3 years down the line whatsoever. So there are certain conditions. If those conditions are met, then only it is going to be applicable. For example, in the phase one, right? All right. So it can be either consent or it can be legitimate use. What legitimate use is? The purpose. Purpose for which the data was already taken, the data was provided. All right. Second thing is, without consent, what else can be done? A state can use, a government can use that data, or the data can be used to providing subsidy, right? What else? Uh, so for example, if there is any court related matter, then also there is no need for consent, right? Medical emergency, some hospital related work, then there is also no need of the consent, because that person is lying on the bed. You're talking about the consent of that person for operating him. So yes, of course, it is not possible. So it is talking about the medical emergencies. And after the pandemic, after the COVID-19, so yes, this point is also clear, for taking measure to provide the medical treatment or health services. So basically, two things. Whenever the COVID was there, right? So no one was coming to you and was asking you that okay, you are having COVID, can we take you to hospital? They were just picking the people and then they were just taking them to hospital and everything like that, and they were treating those people. So basically, for the epidemic also, you don't need any permission. And then for public order, so for example, if there's a public order situation which can happen, so what you are going to do is you are not going to require the consent of the people. you are directly going to take the action to make the situation normal. For the purpose of employment, if you have provided any information, if you have taken any information for the employment, you also don't need to actually take the consent. So consent need not be from the employee. Consent can be from the client or customer. All right, sir. So we have understood these two things. So yes, consent. What is consent? How the consent is drafted? I have understood that as well. And then I am understanding the legitimate use. Okay, legitimate use is number one, the use for which it is there. Uh, secondly, I am going to, if there is any government related matter, court related matter, any subsidy or something like that, medical emergency, public order, etc., etc., then also this law is going to allow me to use the data, the information for the purpose without taking the consent. All right. Then I am saying that data principal is the hero of this act. This is the person for whom this whole law is made, and data fiduciary is the person who is going to comply with the full law. Data fiduciary is possibly going to be our client, right? Then what is this person? This person is responsible for implementing the full provision of the act or rules, and he can appoint a data processor. Basically, I can give that data to a courier person, or say for example as something like that, to another call center person, because I want him or her or the organization to actually call the people who is or who can be the potential customers of my products, right? Then what we are going to talk about is the technical and organizational measures. So basically, when you're talking about the consent management, so on the first day itself, you will have to send the consent to all the clients, right? So how it is going to happen? Are you going to subscribe to some software, or you are going to do some automation yourself? So basically, there are a lot of things which you are going to discuss, think about, and implement. But that is data fiduciary, your responsibility. Don't expect that government is going to come and government is going to do all of this for you. All right, sir. And there is going to be security safeguard to prevent such data breach also. So basically, you have to encrypt your data. How you are going to encrypt the data? So take 256 bit as a, because this is the um, best bit or best encryption that I'm having, and it is easily available. So how I'm going to encrypt my document through 7Z or some other tools, right? So this is a zipping tool, and this zipping tool is doing what? You are zipping the file and you are putting the password. So now your file is encrypted. No one without the password can open that file. All right. Sir, this is the file. I want to send it to the customer, to the client. How would I send them? Because this is in password. This is in password. Then I'm going to send this password to this person. Then what would happen is, if someone is going to hack my email, then he is going to hack my next email. Then he is going to get mails also and a password also. Sir, is it really a good thing? No, it is not really a good thing. So basically, that is why the email is sent through Gmail or something like that, and the password is sent separately, maybe told over the call or sent through the messages, right? So basically, all those things, all those rules, all those organizational measures. So, for example, I'm going to use 7Z, or I'm going to use Excel for encryption, Word for encryption. So, if you want 256-bit encryption, you have to use 2016 Excel or above, and then you can click on the protect workbook, and you can put the password, etc. So basically, yes, all of these things are going to be responsibility of the data fiduciary, right? And what else is going to be data fiduciary responsibility? So basically, number one is setting up all of this. So you are going to set up each and everything which we have talked about here. Then secondly, if there is something wrong which has happened, then you yourself are going to go to the board. Yourself are going to go to such person whose data is lost or stolen or whatsoever, and Both of these intimations are the responsibility of data fiduciary. Sir, in how much time you have to do the note the intimation? In 24 hours, you have to just do the implementation, or 24 hours you have to do the intimation. Okay. Then if that person says, okay, erase my personal data, I don't want to keep it, you have to erase the personal data also. Or for example, you have given data to courier person, you have to get the data erased from that courier person also. Then, for example, that work is done, then you don't have to retain the personal data. So basically, you will have to say that for example, our tax return preparation, for our advisory services, something like that, you have to take the consent for the period before the work finishes. So, for example, for 3 years, you have taken the consent that 3 year return I am going to file. Then, if there is some other law which says that you have to retain the data for longer period, then you will have to retain the data for that longer period also. All right. Sorry, I have got to the last page somehow. Okay. All right. Then implications of the data breach. If the data breach happens, then you are going to have a penalty. Any unauthorized processing, any alteration, any loss, any destruction of data, then you are going to have a liability. And even accidental disclosure. Say, for example, your computer was open and someone stole the data, your computer was locked, and even then the hacker comes, then also you are going to be liable. And for example, you sent data over email and you by mistake sent Sham's data to wrong data, then of course you are going to be applicable. You are going to be liable for this, right? So this is going to be the data breach in each and every case. Now, after the data breach happens, what is going to happen? You are going to have the penalties, right? Okay, we understand that, and you know that how to keep the data secure. This is a very important question which is going to come, and this is how you are going to keep the data secure. First of all, you have to make a policy, and what those policies are going to be, those policies are going to be for keeping your data secure. For example, you are going to keep every file password protected. You are not going to disclose the password. Only password is available with the person who are working on those files. You do not only, you're not sharing you're not having a common password for whole of the form files, for example, and you are not sharing the information with anyone and everyone who is there. You are just using your information for the purposes which are mentioned in your agreement. Then you can say, okay, dual authorization. Okay, if two persons are authorizing the same thing, log off or lock the worksheet before moving on. Protect from physical theft. You just disable the memory card, use pen drive and hard disk, etc., etc. Store data on central encrypted drive. Again, the same encryption thing that we discussed earlier. Backup was should be proper, otherwise that person says that I have this data and you change the data from this to this, then you are saying that I don't have any data. Why? Because my computer was stolen, or my computer was here only but got crashed, right? So you have to maintain, not only you have to keep the data secure, you have to keep the data also. You can't let it delete on its own, because when you are going to delete the information before 48 hours, you have to mention it to the data subject or data principal that yes, I am going to delete your data, please come if any changes or anything you want us to make, or don't you want us not to delete, then you please tell us. All right. Then you have to have disclaimer in on the emails. What kind of disclaimer is going to be there? That yes, if you are getting some data by mistake, please revert and please delete the data which you have got. So this is a disclaimer. Although this disclaimer is not going to save you, this disclaimer is going to show that you have taken steps in the direction of keeping the data secure. Okay, sir. All right. There has been a lot of things that we discussed. Now it's the time to see certain things that we already have, right? Okay, what are those things? There are certain other templates also which are there. So for example, this is for financial advisory, that is fine. So if there is a breach which happens and you have by mistake disclosed some information, or for example, there has been cyber attack, or the laptop is stolen, or anything like that has happened. So what you are going to do is you have to immediately notify. First of all, you have to immediately notify whom. You have to immediately notify both the data protection board and both the firms, right? So basically, data protection board, you have told that yes, this data is has been lost or shared, and that person also you have mentioned that yes, this data which belong to you has been lost. Okay, and what is the format to the Data Protection Board of India from this date this, and what is the incident number? For the tracking purpose, you have assigned the incident number to that particular thing. And what is the brief summary when you discover? And very important thing is you have to notify within 24 hour of actual happening. No, not actual happening, of the discovery date time. So whenever you discover that yes, there has been this problem, you have to intimate to the data protection board immediately, and you have to intimate that client within 24 hours. All right, what is the discovery time? What is the estimated occurrence? So basically, okay, we discovered today, but when did it happen approximately? What is the current state? What you are doing? You are investigating, you are containing, or it is resolved. What is the thing that is happening? And what is the affected data? Okay, we had this 10, 20, 30 data, and these data are gone, or these data are actually shared. What is the sensitivity label? Was it internal? Was it already public? So these kind of uh, data labels should also be included or in the intimation that yes, there has been a breach. And what is the nature of the breach? You have unauthorized access or accidental disclosure. What is the method? What is the data compromise? What are the immediate actions taken? What I am going to do? What are the potential consequences which can happen? What are the contact information? This is my team which is working on that. And there is a data protection officer information also which needs to be provided. So, in who is going to be the person who is going to resolve the issues related to data protection? All right, and thereafter, detailed report to follow within 72 hours. So, basically, within the first 24 hours, you have mentioned that this is the data which is lost, and these are primarily the implications, right? And thereafter, in 24 after 24 hour, within next 48 hours, you will have to file a detailed report. And what is the detail? What is the timeline? What is the root cause? What is the impact assessment? It is going to be a comprehensive report. Why this comprehensive report is there? So that the organization first of all knows that yes, this is the data breach that we have done, and this is public. And second thing, your organization is also dealing with the public data, then of course people should also know that yes, you are one of the culprits. Although of course, what the organizations or the data protection board is going to do with the data, then that is something that we need to figure out, right? What is the full impact assessment? What is the complete list of principles, categories, technical analysis? We have what has been the failure assessment of ongoing risk? What is it? Then what are the external notification that we have notified this principal, the authority, etc., etc., and our professional indemnity insurance also notified. All right, and you have to give the notice to the client also. So to the client, you have to give all of these things, that you have to mention also your rights under DPDP Act. Then we're going to talk about data protection impact assessment later on. Why? Because it is for SDF. Okay, now what is SDF? So there are two kind of persons, data fiduciaries, DFs. Basically, one data fiduciary is normal, one is significant. Significant means bigger data fiduciary, the organization with it, which is big. For example, it can be a bank, it can be an IT company, it can be Google, Facebook, Meta, or any, right? So it is what it is saying. It is that class which is having the volume and sensitivity. So you are having very sensitive data. For example, you're Fortis Hospital, right? You're a health company, you are a media company. So for example, because whatever you're going to say, the sovereignty and integrity is also going to be impacted, right? So a lot of different things are there which defines the significant data fiduciary. And for the significant data fiduciary, there is going to be applicability of consent, there is going to be applicability of legitimate use, there is going to be applicability of the security of data and not disclosing the data unknowingly. There is going to be applicability of my team will use or know about that data only which it is required to use only. All those are going to be applicable, but in addition there is going to be other things also. What other things are there? So first of all, there should be a data protection officer. Okay, so there should be a dedicated person who is going to be India based, right? And he is going to be an individual. It cannot be a company, right? So there should be one person at least who is going to be there to answer all the questions, to resolve all the things, and to get all the grievances resolved. Sir, but you mentioned about the data protection board, that data protection is there. If you are having any grievances, you go to data protection board. But yes, you can go, but before that, you have to go through the data protection officer. And then, if he is not able to resolve, then you can go to the data protection board. Data protection officer and data protection board, are they separate? Or this is one and this is a board? No. So basically, this is the organization's data protection officer. It is appointed by that organization only, but this is the government's data protection board. So if it is not resolving, then you are going to go to the government. Second thing is he has to carry out the independent audit, data audit, right? So you have understood about a lot of different audits, content audit, internal audit, statutory audit, a lot of different audits. But one more audit is going to be joined. It is going to be data audit. Okay, sir, what is going to be included in data audit? So a lot of different things are going to be yet to be notified, but we are going to discuss what exactly is going to be part of the data audit in the coming few minutes. Okay, sir, what else? And he has to undertake periodic data protection impact assessment. So basically, what it has to do is it has to just see what all data I have. If the data is disclosed, what is going to be the impact, what is going to be the loss, what is going to be the circumstances, and how I'm going to cure that, etc., etc. Right? Okay, sir, let us understand how the DPIA, data protection impact assessment, works. Okay. So, for example, if I just show you data protection impact assessment, sir. Okay, so there are a lot of questionnaires. There's going to be a template that you or your staff or some external agency who is doing this DPIA is going to fill. They are going to go to every project or every service. What is the date of that DPIA and who has done that DPIA? Okay, all right. So what is the criteria? High risk processing indicators, right? If there is a large scale processing of the data, right? When high risk is there, when your company is used, the information is used worldwide, a lot of people are talking to each other, for example, TikTok, Facebook, Instagram. So what are the high risk processing indicator? New technology is involved. Data principal impact is going to assess processing scale. What is the processing scale and what are the screening result? First level screening is this, whether full DPI is required. If it is high risk indicator, then you are going to do the full DPIA. Otherwise, you are going to say, okay, simplified this particular DPIA is also sufficient. But if you want to do full DPIA, then what is the project? what are the processing detail, what are the data types, etc., etc., what is the purpose, who is the recipient, what is the retention. So basically you are just making a list of the things so that you are aware, you are going through each and everything, and then you are going to do the impact assessment. What is the legal basis for processing? Is it a consent, it is legal obligation, etc., etc.? What is the data flow map from where it is coming and from for where to where it is going? What are the different risks? What is the likelihood? What is the impact? What is the mitigation, right? And for example, what are the DPDP requirements? For example, these 4 5 requirements are there around this. For example, for consent management, what is the control that you're having? Is there any gap? Is there any action required? So a detailed report you are going to fill. Stakeholder consultation you have done, monitoring review is happening or not, mitigation measures are there or not, and approved by whom, right? So basically you understood how the DPIA, data protection impact assessment is done, right? So this is how it is going to be done. Then let us come back. Now let us talk. We have talked a lot about the data fiduciary. We have talked about the significant data fiduciary also. Let us talk about the data principal, who is the second party in this law. Who is data principal, sir? Is the hero of the act, and he is the person. Uh, he's the person whose data is there, whose data is actually roaming around, flowing around. He's the person who gets a lot of calls from different companies. All right. What are the rights and obligation of that person? He can anytime ask the summary of the personal data. So for example, he can write an email and say, okay, tell me what all data you are having about me, and you tell me what all the other people you have given my data to. For example, Zomato or Swiggy, or the parcel companies, or you have given to any Noida builder, or whom you have given my number. So basically, all the information he can ask, and then of course he can say that if this information is wrong, you correct that, or he can say, okay, I don't want you to hold this information, you delete it. So there are a lot of things. There are a lot of rights that this data principal is having now, and right to grievance also. But right to grievance is only after it has talked to the the company, the data protection officer. Only then it can go to the board, otherwise not directly. All right. Duty to comply with the law. So there are certain duties also that he is having. So the small duties he is having. First of all, he should not give any wrong data. He should not say that I am president of India. Of course, he is not going to give wrong data. He is not going to impersonate, becoming someone else. He is not going to suppress or hide any information. He is not going to make a false compliance, and going to provide only verifiable, authentic information. So, what would happen if he does not provide the right information knowingly, unknowingly, or something like that? Then data principal is also going to be penalized. Yes, you're right. The data principal is also going to be penalized, but the penalty is very small as compared to the data fiduciary. All right, sir. All right. Are there certain exception also? Right, there are certain exemption also. We understood already that judicial cases are exempt. For example, if there is any law or compliance happening, that is exempt. Or for example, there is any legal right or claim enforcing is happening, that is exempt. Then for example, it is for the amalgamation or any similar arrangement, and it is approved by the court. Again, the court came, it is exempt. But this fourth thing is a bit different. For example, if I am here, there are a lot of call centers in India which foreign companies are having. So basically, there's a foreign company. That foreign company is having a foreign client, and they have got a center opened here, and I have got the data from that foreign company. I am calling to that foreign client of that company. Then this law is not going to be applicable. Sir, can you repeat? Yes, I can repeat. You remember the opposite of this. If a person is calling a person in India, right, from outside India, then this law is going to be applicable, right? So if a person is calling from outside India into India, then this law is applicable. If a person who is calling from India to outside India, this should not be applied. Sir, in that case, no law is going to be applied. No, in that case, that country's law is going to be applied. Okay. So basically, just read it. Processing of data principle outside. The principle is outside pursuant to any contract entered into with any person outside the territory of India. Why you are calling that person? Because you are having any contract with a person outside India. All right, sir. So these are the exceptions. Okay. And there can be certain exemptions which can be given by central government till 5 years from the date of commencement of the act. So the act is not yet commenced, it is not notified yet, and till 5 years it can give the exemptions. So a thing is mentioned already in the law. So basically, you understand that there are intentions of the government that it yes, it is going to be in the phased manner, and how the phased manner is going to be made. So basically, there's a time span of 5 years in which first year, second year, third year, fourth year, fifth year, it is going to be applied to certain people. It is not going to be applied to the other. Okay, for example. Or what are the other exemption? They can give any exemption to, for example, startup. They are definitely giving exemption for research, archive, or statistical purposes. And if it is so basically for research purpose, for different checking, sir, is chat gpt going to be part of this research purpose, archiving, or statistical purpose? Of course this ai is statistics in itself, but it is very subjective whether the ai can use this data or not. But yes, prima facie no. Okay, all right. What else? There are a lot of miscellaneous provision which are about the data protection board, about the appellate tribunal, because the data protection board is there. If the decision is not in your favor, then you are going to go to the appellate board, and that is how the mechanism is there. If appellate tribunal is not able to resolve, then high court and then supreme court. So that is the natural path is there, which is going to be followed. So section 31 talks about the dispute resolution, and 32 talks about the voluntary undertaking. All right, sir. Now, what is DP board and appellate tribunals? We have talked about it. The data protection board is going to be there, and the appellate tribunal is going to be there if someone is not satisfied. So, data protection boards are yes, it is going to be having the chairman and members who are going to have specialized knowledge in this area. Then, second thing about this board is it should act as a digital office. That means, sir, the hearings, etc., is going to happen digitally. So it should be digital by design. All the forms, etc., everything is going to be digitally only. Fine. The board or its officer shall not prevent uh, or not take into custody any equipment. So basically, unlike any other law, they are not going to seize the computer, etc., etc. So if you're not satisfied with DP board response, then you are going to go to the appellate tribunal, uh, and you can go here till 60 days of the judgment. And the idea is that this appellate tribunal will complete the whole investigation and give the decision in 6 months. So basically, there's a endeavor to fast track the things, right? Then, of course, there are some amendments to the other law also, because for this law, there were earlier other laws which are applicable, and for making way for this law, there are amendments which are made to other laws. So, just talking about that. All right. Now, what are the factors to be considered in the penalties, etc.? So, before going to penalties, let us just stop for a while and let me show you some other things also. All right, sir. So basically, are there going to be any agreements also which I am going to have? Yes. So basically, I am going to have agreement with my vendor, with my vendor, because I'm going to share the data with that person, and whether that person, that organization is using the data in the proper way or not. Otherwise, the penalty, the liability is going to come to me. So I have to protect myself also by way of a various agreements. And of course, we are going to talk about the indemnity, etc. also. So yes, this is something which is already there. Okay, all right. So what about the vendor data protection? So first of all, you'll have to make a due diligence for the vendor, right? What is the company? What are the data processing details? What they are going to use for? What are the data category they are going to have? What are the processing activity they already are doing? Or for the first time, for example, if what are the processing activities which they are generally doing for other organizations or entities? Then what are the legal and compliance things, whether they are acknowledging DPDP Act applicability. So there is no vendor which says no, DPDP Act is not applicable yet. So if after 1 year also they say, then of course all of these things are to be checked. What are the technical securities that they are having? What are the measure? What are the various certification of systems or of the organization teams, etc. What are the operational controls? So, for example, their staff is having the role-based access. So, if I am working in the income tax department for 10 clients, then I should get only that information, or I am able to access only that information for 10 clients and for the income tax number, right? And what is the incident management? How the incident management is done? So if there is something which is happened in the past, how if the incidents are managed immediate, or they just don't respond after the incident, or so basically this is something. Data location and data transfer. This is another important thing, that data location where it is very, very important. Okay. So where the location, etc. is. And then after this assessment, you are going to do data processing agreement, or you can do the data assessment, your vendor assessment every year also, so that you are aware that nothing has changed. Now, data processing agreement is what? So it is just like any other agreement between two parties. What are the definitions? What you are going to do? What you are responsible for? How the sub processing is going to be done if he does not do, and if he send the data to someone else also. So basically, it was with me. I have sent to you. You will send to someone else, someone else, someone else. So you have to mention about that also, whether it is allowed under this or not. Then audit and monitoring. Audit, how the audit are going to be done, how the monitoring are going to be done. Can we come to your organization? Can we ask for some data? Can we do the data audit at your organization also? How the data transfer is going to happen? Who is going to be liable for this, and what is going to be the indemnification? How the termination is going to happen? So all of these things, right? And then let me just come back to this DPDP. Okay, now we are going to talk about the penalties. And before we move on to penalties, let us stop for 5 minutes. Not 5 minutes. Let's pause for only 2 minutes. It is 6:28, 6:30. Let us resume. Right, 2 minutes break.
Sure, sir.
All right, let us resume now. Now, of course, we talked about a lot of different things. 4, 3, 2, 1, right? There are where's the pen? One second. There are four terms, that digital personal data protection. There are three parties. There are two ways in which you are going to use the data. Now, the thing is, there is one penalty clause which we are going to talk about. So the penalty is the main attraction point of this law. Why, sir? Because the penalties are huge. The penalties are what? The penalties are extending till 250 crores. Okay. But sir, there is a penalty of 10,000 also. But this penalty is for the data principle, section 15. So the hero of the act, this person is having the least of the penalties. So, and this is a maximum, right? But for others, it is 200 crore, 250 crore, etc., etc. And per incident, it is 50 CR, right? Per incident means for one particular customer or client, if there is a data breach, 2, 3, 4. And so the maximum limits are these, right? And in the law, it is mentioned that by way of rules, this can be actually extended, but it cannot be more than twice, right? So this 250 can be made 500 CR also later on through rules, but yes, these are the penalties. And we understand that these are not the penalties just for the namesake. They are not just telling you that there are huge penalties. So be aware of this. These penalties are actually implemented, and these penalties are actually applied and also recovered, and we have seen in the GDPR cases. So this is going to be the same in our country also. All right. So when we talk about 250 CR, so it is going to be straightforward 250 CR or maybe something lesser also. Yes. So when applying the penalty, the board is going to determine how the penalty is to be computed, or what are the factors which are going to be considered for arriving at the penalties, right? So basically, they are going to see what is the nature of the data breach, what is the gravity of the data breach, what is the duration, since 2 years, 3 years, 5 years, you are doing the data breach, you are disclosing the data to some other entity, some other organization, or your data is open in the public, anyone can come and access, right? What is that personal data? It is just name, or these are the credit card details. So you'll have to see those things also. What is the kind of personal data? Is it a repetitive nature of breach? Last year, last to last year, 3 years back also, you were caught sharing data, selling data. Is it a repetitive thing? What are the gain made or loss avoided because of that? Okay. The gain made means you have sold the data. Loss avoided means, or cost avoided means, you have not taken the appropriate security measures, and that's why you have avoided any loss or cost. What are the actions to mitigate the effect and consequence of breach, right? So when I mentioned that you have to put in a disclaimer in your email, then I was referring to this point only, that you have taken steps for mitigating the effect so that there cannot be a huge impact. You have mentioned to that person that please delete the email. You have mentioned to the person that yes, you tell me that yes, you have got this information by mistake, right? So basically, in that case, I will be aware in 24 hours. I have to mention it to my client, and I have to mention it to my protection board, and in 72 hours I have to give the detailed report also. So basically, it will help me do all the compliances very very fast, sir. 24 hours is a very small time. How I can give the report? And 72 hours is also a small time. How can I do a lot of investigation, in-depth investigation, and how I'm going to submit the report? So for that, you have to basically have all the procedure in place in advance. Although there has not been uh, not been a disclosure, or unknowingly you have not sent it to someone, but or there has not been any data breach, say for example, by way of any cyber attack. But what you are going to do is you are going to actually have all the templates ready, all the procedures ready, so that as and when it happens, you are actually able to submit everything in 24 hours or 72 hours, whatever is the case, right? And what are the things? Okay, what are the actions it has taken to mitigate the effect? And then it is talking that is the penalty going to be effective? How you are going to decide whether it is going to be effective? So basically, if you are a company who is 10,000 CR turnover company, if I apply 2 crores of the uh, penalty, then it is going to be a big amount. Of course, 2 crore is a big amount. But for the company who is 10,000 CR turnover, for that company, it might not be very big amount. If you say apply 100 crore or 50 crore penalty, then that company will be serious about it. Otherwise, that company might not be taking you seriously, the breaches seriously, or the compliance seriously, or the law seriously. So basically, the board is going to decide how and how much penalty is going to be effective, right? And likely impact of the imposition of the penalty on the person. So if the penalty is going to be imposed, what that person is going to do? So basically, is he going to be able to arrange those money or not, that money or not, or that company or that entity is going to be shut down because of our huge penalty? So basically, you will have to decide and keep in mind all of these before applying the penalty. And the penalty then can be anything between 0 to 250 CR, right? Okay, so basically, let us see some other templates also. What are other things that we have to keep in mind? So basically, next thing is training, which we can avoid. Okay, training can be very much subjective. So this was my focus of training, right? So basically, what role specific is fine. This is also again the same thing. Okay, so you have to maintain a training record and compliance tracking also. How? So you have sent the consent, then you have to you have maintained that also. Okay, all right. You have maintained the information on the data protection impact assessment. Okay, how, what is going to be the impact? You have made a lot of agreements with the data processors. That is fine, but at the same time, you have to train your staff also. Okay, how they are going to save the information, the files, right, in the central repository, or they are going to zip it using 7Z, right? So it is going to be 256-bit encryption. Now what this 256-bit encryption is, everything you are going to tell, or you are going to put password using the Excel protect document feature or Word protect document feature itself. So there are a lot of free tools also, there are a lot of paid tools also, how you are going to take the backup. So all of this training, so you have to mention that, okay, what is the training type, and what is the compet duration score, what is the trainer when it is next due, right? Then you have to mention that, okay, uh, they have any DPDP knowledge, their practical skills, their compliance behavior is what, right? Then for my training dashboard, okay, what percentage of the staff trained, what has been the score. So basically, you are going to maintain all of these things. What are the annual training plans? So basically, of course, a big entity should maintain all of these things, right? So basically, this is what I wanted to discuss about different templates. Then let us move ahead further. Right. These are the penalties, issue challenges, if that's okay. Right. What are the contribution by chartered accountants? So basically, we are going to audit the sensitive industries. So what are the sensitive industries? The bank, the health, the insurance, IT, and other industries. So basically, this is something which we should be mindful of, because these industries are having this sensitive data, and basically we are actually certifying a lot of things. Basically, we are signing a lot of certificates. So it is possible that we need to certify this also, that this organization is having proper data, uh, data impact assessment, is having proper data audits or proper data procedures. say for example. So basically, we don't really know what is going to be the practice that the organizations are going to follow, because till now the law is itself not applicable. And then, of course, initial impact assessment you can do, you can design the internal control procedure, you can design the policies of the organization. Okay, whenever a data comes, so that flow chart that we are talking about, okay, what will happen? You will take the consent, you will save the consent here, and then later on, you will save the data here, you will make a repository or an Excel sheet of the data, say, for example. So, whenever this person comes with an email, you can just go to this master Excel, and then you can change this data here, and then it changes other places also. So basically it is possibly not going to be on the spreadsheet. Another thing, because there are certain software, the dedicated softwares which we talked about, and this is just a one list, right? This is just one list, this is not comprehensive list. But of course we can go to these websites and we can see what is the thing that they are offering, how they are offering those things. So basically, it's not necessary that we take their help only. So basically, in the Google Workspace, Google Sheets also, you can have the app script, and then what is going to happen is they are going to that is going to read all the emails. It is going to mention the specific type of data in this sheet, and then whenever there is an email which is coming up, that yes, I this is regarding the change of data, and then it can change the data in here also, and then at the end of the day, it can give you a complete report to you also. So that automation can be done by yourself also, and you can take the help of these software providers also. Another thing, but it is a fairly early phenomena till the time it is not applied in reality, because government is also facing a lot of comments, or a lot of opinions, or a lot of uh, pushbacks regarding the applicability. Because if you read the law, and there are a lot of things which are mentioned, that you have to keep the encryption, etc., etc. But how that encryption is going to be 256-bit, or what kind of, so basically all those things are to be decided, right? Otherwise, so notice for consent, this is already decided. So notice for consent, yes, we can be part of it, but that consent management is going to be handled by the organization which is having 2 CR of turnover, and which is having certain expertise in this area. So basically, it is not going to be a CA firm for sure. So if the CAs want to work in this area, they have to make a separate company. So we are going to discuss about those rules as well. Okay. Then data protection officer, yes, of course, you if you are good at the data things and the representing client before DP board, this is definitely our thing. That yes, if there are 5 crore, 10 crore, 50 crores of penalty, and you are representing that person in the data protection board, definitely it is going to add a lot of good worth to your current practice, right? And then, of course, the compliance of the law, since we are actually actively involved in the compliance of each and every law, then this law is also our responsibility. Plus, we are having clients, we are also running an office. Then there are responsibilities also, compliance requirements also on our organization. So, how we are going to comply with these laws or these rules? So do we also have to take the consent? Do we also have to actually maintain the data, and do we also have to make that flow chart, okay, of how the data is flowing, data library or data documentation, everything we have to do? Yes, the answer for now is yes. But again, not from the first day is what I believe, because it is going to be in the phased manner. And of course, the top firms, say for example, who are having turnover beyond this, or who are having, for example, listed clients or something like that, then on them this is going to be applicable on the day. Okay, is it going to increase the cost of operations? Yes, it is definitely going to increase the cost of operations, or cost of efforts basically that we are putting in, because there's going to be a lot of consciousness actually. So more than the effort, more than the money which is involved, it is a lot of consciousness around the data. Okay, I am having what data first of all, and should I have these all data also, or should I say, okay, no, sir, don't provide this data to me because I don't want to maintain an industry. I don't want to maintain each and everything about your data. Okay, having this much data about you, just give me the information which is required. So basically, two things again as a conclusion that we want to draw. Number one is, of course, we have to be a part of the whole ecosystem. Secondly, we have to keep in mind that yes, we don't get unnecessary data and store it here or there everywhere, right? Okay, all right. And of course, these were certain things, and this is a general distinction between GDPR and DPDP Act. So, what are the differences? The GDPR says 4% of firm worldwide annual revenue. This percentage is not there. If 10,000 CR and 4% is going to be 400 CR, it's not there, right? Okay, so this is a good thing here. And minus under age 19, there is a parental consent also. Here 18 is the age, and here it needs to be 72 hours. Here also it is 72 hours now. It was as per the rules. And it does not include right to nominate, right? And then organization a 30-day respond to a data subject request. This is additional right to nominate here also, which is an important thing, right? So these are the differences that we are having. Now let me show you the rules, right? So this is about the rules. So rules, we more or less we have discussed together. So there, how many rules are there? And so the major rules are there. For example, this rule. One second. Let me. Okay. Okay, all right. So rule 3 is talking about how you are going to give the notices. 8 is talking about the security safeguard, and rule 10 is going to talk about the what are the notification protocols. So if there is any breach, what is going to happen, and then how you are going to retain the data, you are going to delete the data or not. And then consent management, yes, the rule 4 to 6 is talking about that because you are going to give the notice and then you are going to maintain the consent. And data principal rights, okay, it is also mentioned. SDF is also mentioned, and there are other things also. Okay, all right, sir, we understand that. Okay, yes, January 3, all right, it was given, and then February 18 was the first date. Thereafter March 7 was the date till when the rules were to be publicly commented. 22 rules are there, 7 plus 7 schedules are there, right? So yes, I will take you through the rules by the actual rules which are there, and this is a presentation around that only. Now first of all, let us talk about the rule 3. So it is, first of all, it says that it should be a standalone notice, so it should not be a, it should be separate from the terms and conditions, right? And the notices should be accessible. So whenever the data principal want to see, okay, what I have actually signed, so it is able to see that notice, right? And then required notice consent content, what should be there, it should be itemized. It should not be a paragraph so that after reading it you are not able to understand what it wants to say. Proper heading, proper paragraph, right? And what should be included, all data sharing and withdrawal steps, etc., etc., everything should be there. All right. And of course easy consent withdrawal should be there. So if the person has given the consent, it should be easy to withdraw. So same things here, rule 8 when we talk about it. So there are technical safeguards which need to be meant there, and then organizational safeguards. For example, you need to have backup, incident response, all of the procedures, policies should be made properly. What are going to be the encryption? So, and my understanding is this AS256 encryption is advanced encryption standard, right? And so this should be 256. What is 256? 7Z and your Excel, Word, PowerPoint 2016 onward. So when you save it there and you do add a password, then it is 256 encryption only. right? And how you are going to share the password and with the client. So basically, you are going to send your email through another means, your document through another means, and your password through another means, mode of basically communication. So yes, this is all what we have discussed. Your trails is not a requirement for now, but in the GDPR is a requirement. Here in DPDP is not a requirement. Okay, then you have to maintain the backup, training, etc., etc. So all of this is mentioned. Whenever there is a breach, you have to maintain you have to mention it in 24 hours, and then in 72 hours full report. It should be in simple language, etc. And protective actions, what are the done. And it can be a email misdirection also. You lost laptop, you unauthorized access is given to someone, or cloud provider security incident also can be there. For example, Google Drive data is, for example, leaked. So it can be that also. All right, what else, right? So it should be in 24 hours. I have already mentioned, and you have to keep the notification templates, etc., ready, which I showed you already. And there should be a proper response team or incident management procedure, basically, not team. Then, okay, what are the timelines? So for 3 years for e-commerce, social media, and online gaming platforms, so the data require retention, and deletion must be systematic, and before deleting you have to give a 48-hour advance notice before deletion to the data principal. All right, sir. All right. And you're having multiple data types, etc., etc. So all of these information are more or less repeating, right? And consent should be free, etc. With this we have already discussed. And of course, training is a requirement. And when you talk about the data principle, right, you already know that he is having the correction right, he's having erasure right, he's having information right, he's having grievance redressal right, etc. Now let me show you the bare rules also. So these are the rules which we are talking about. So for example, and this is only so this is 51, half of it is 25, so it is 25 page. Why, sir? Because it is both in Hindi and English. So still 25th page it is in Hindi, 26th page is also in Hindi, then 27 also, 28 from page number 28 it is starting. Then what is the rules? 2025 rules. Okay, notice first of rule 3 says notice to be given by data fiduciary to data principal, which we understood. How the consent manager is going to register the conditions of consent manager. So if you go to first schedule, if you go to first schedule, okay, okay. So here is third schedule. If you go to first schedule, so yeah, first schedule is this condition of registration of consent manager. Net worth is not less than 2 crore in company incorporated in India. So that is very much clear that a consent manager is definitely a company, and it should have a platform where data principal can come and manage, review, withdraw. So basically it's a portal where that thing can happen. It is not expected to be flying over emails. That is the first important thing. But then what about the MSMEs and other organizations? So yes, this is going to be modified in some way or the other. And so basically, this is not the final rules. Actually, these rules were actually notified and given out for the public comments. So the final rules are yet to come. Okay. What are the obligations of consent manager? Let us now go back to the same place. Okay. Yes, the consent manager is there processing for provision of subsidy benefit, how the state instrumentalities are going, and who is going to be the person. So they are going to notify one person that this is the authorized person for all the practical purposes. right? Reasonable security safeguard. What are the security safeguards? So you'll have to do encryption, obfuscation, and masking of the data. So basically, you're uploading any data on any application or something like that. You have to mask the data. You have to anonymize the data. All of these things are to be done. And of course, so there should be a technical hand or requirement. So you are understanding the technology is taking over, and it this law applicability is on the right time because there is AI for helping us a lot in different things, right? Intimation of personal data breach. Yes, this is how you are going to intimate. So it says, okay, without delay, any mode of communication, right, which is there. So basically, all of this we have already understood and got. Okay, for the where DPDP rules, sorry, for the act, okay, act is also how many sections are there in the act? In the act, there are only 40, how many 40? I think 45 sections. 44 sections are there. So all of these things we have already covered. Now what I will do is I will just stop sharing my screen, and if there are any, or before that, let me share my details. So if you want to questions, and thank you. So these are my details if you want to contact me. And thereafter I will just stop my screen just to have any questions which I have. All right.
Thank you so much, sir. So there are so many questions. Um, are there any specific law on data protection?
So this is the only specific law on the data protection in India. Other laws are also there. For example, Information Technology Act is there, so which is protecting your information and wherever there is any cyber attack or something like that. So that was covered there, any obscenity or something like that. But for now, this is the only Data Protection Act which is there in India, which is going to be there in India.
Okay, the next question is by Aparna. Data principal can be an organization.
Data principal, as per this law, cannot be an organization. It has to be an individual. Aparna.
Next question is by Sunil Reddy. Hi, sir. Should we attach any FIR while giving intimation to Data Protection Board?
No, so nothing about FIR is mentioned. It is simply a case of data loss. No FIR provision is there. It's going to be handled by DP board only.
Again, the same. What if a staff saving the company's data in their personal emails?
So that is not allowed. First of all, you have to sensitize staff, train staff, and again, it is more about creating that data culture. So yes, that does not have to be stored, and you also need to disable the pen drive access, etc. And the law says till the extent that so till now, if right now what we are having is everyone in the firm can access any information, but in corporates we know that it is from the very beginning like that, need to know basis. So everyone has the information that they need only. So yes, that's.
Okay. Next is from when this DPDP Act was made applicable.
So this law is not applicable yet. It was passed in 2023. The rules are notified in 25 January, but again, well, sorry, not notified, were out for public comments in January 2025, but not yet notified. They have got the public comments. They are working on that, but they have not come back.
Okay. What redressal process is available in case of breach?
So if there is a breach, first of all, the organization has to intimate the client and or the person whose data is there, data principal, and to the board in 24 hours, and then 72 hours it has to submit the detailed report, why it happened, what it happened, etc., etc. And thereafter, of course, an instance is going to be filed there, and the hearing is going to start. So that's the procedure. And then if you're talking about the remedy, the thing is only about the penalties. If you're thinking that there is going to be any compensation which is going to be given, compensation is not mentioned in this law. It was mentioned in the Information Technology Act, but not this.
Okay. So once again, can you share your contact details in your PPT so the member can take the screenshot from the same?
Yes, I will just share my screen, and meanwhile you can just tell me the other questions. I've shared.
So yeah, so that was the last question only. No other questions are left.
Perfect. So yes, I shared it and I'm stopping my screen again. All right.
Thank you so much, sir, for your insightful and enriching session. We truly appreciate your time, effort, and knowledge you shared with us today, and it was extremely valuable for all of us. And more than 200 plus members joined this seminar. So thank you, all of you. I hope everyone take the screenshot. So we are ending the session over here. Thank you. Thank you,
Thank you.
sir.